Before we begin, here is a question to sit with. Have you ever had to do something significant for someone who did not deserve your help? Not because they had earned it, not because the history between you made it easy, but simply because walking away from a wrong thing was something you were not capable of doing regardless of who was at the center of it? Drop your answer in the comments as you listen. The courtroom was silent in the way courtrooms go silent before a sentence is delivered. The kind of silence that has weight in it, that carries the specific gravity of a moment everyone in the room understands is permanent. Ethan Cole sat at the defense table in a charcoal suit that had fit him better 6 months ago, before the trial, before the depositions, before the specific physical erosion of a man watching his life come apart in front of cameras and gallery seating, and a jury of 12 people who had listened to 4 weeks of evidence and found him guilty of securities fraud, wire fraud, and conspiracy to commit financial crimes against the investors of Cole Technologies. Life in prison. That was what the prosecution had asked for. That was what the judge was preparing to deliver. His lead attorney, a man named Harrison who had taken $2 million of Ethan's money across 16 months of pretrial preparation, had run out of arguments and was sitting with the specific stillness of someone who had already begun to emotionally detach from the outcome. The judge had picked up his pen, and then the courtroom doors opened. The sound of them opening was quiet. The kind of sound that should not carry across a full courtroom. It carried. Every head turned. A black woman in her early 40s walked through those doors in a dark navy suit, natural hair pulled back, a leather briefcase in one hand and a document portfolio in the other, moving with the specific, unhurried purpose of someone who has made a decision and is implementing it. She walked to the front of the courtroom. She said, "Your Honor, I apologize for the interruption. My name is Dr. Vivian Cole. I am entering an appearance as counsel for the defendant." The judge looked at her. The prosecutor looked at her. Harrison looked at her. Ethan Cole looked at his ex-wife and felt something happen in his chest that he had not felt in 4 years. There is a specific kind of strength that does not perform itself. It does not arrive with speeches. It does not require an audience. It shows up in courtrooms on the worst morning of someone's life and places a leather briefcase on the defense table and says, "Your Honor, I apologize for the interruption." This is a story about that strength. It is also a story about what it costs to possess it, the years of work that produced it, the marriage that fell apart inside it, the specific, accumulating price of being exceptional in a field that was not built for you. And it is a story about a man who had everything and gave nothing and found himself, on the worst morning of his life, looking at the only person who could save him, the person he had chosen, repeatedly, to not be present for. She did not walk into that courtroom because she forgave him. She walked in because the evidence was wrong and she could see it, and walking away from a man being prosecuted unjustly was something she was not capable of doing. That distinction matters. That distinction is the entire story. If you have ever done the right thing for someone who did not deserve it, simply because it was the right thing, this story belongs to you. Before we begin, one asks, if this story finds something true in you today, right? She showed up anyway in the comments. Let this family know you are here. Now, let us begin. Ethan Cole had built Cole Technologies the way men of his particular construction build things. Through a combination of genuine engineering brilliance, appetite for risk that other people found reckless, and that the market repeatedly rewarded, and the specific, unchecked momentum of a man who had never once been required to slow down for another person's sake. He had grown up in Dallas, the son of a petroleum engineer father who had made and lost a significant amount of money twice before Ethan was 12, and who had given his son, through those cycles of abundance and collapse, an early education in both the mechanics of ambition and the specific fragility of everything built without a foundation that was not about money. He had gone to MIT on academic merit, not family connection, and had emerged at 23 with a degree in electrical engineering and the particular confidence of someone who understood complex systems at a level that most people around him found genuinely impressive. He had founded Cole Technologies at 28. By 44, he had built it into a publicly traded technology hardware and software company with operations in 14 countries, 42,000 employees, and a market capitalization that had briefly, at its peak, exceeded $90 billion. He was 48 years old now. Cole Technologies was in receivership. The company's market capitalization had collapsed to approximately $3 billion following the initial fraud charges, which had been filed 14 months ago and had gathered the specific, accelerating momentum of a corporate prosecution that had access to the internal communications of a company whose leadership had not been careful about what they said to each other in emails. He was sitting at a defense table about to be sentenced to life in prison. He had gotten here through a combination of genuinely bad decisions, a CFO who had been conducting financial operations that Ethan had known about at a general level and supervised inadequately, and a prosecution narrative that had taken those two elements and constructed a story of deliberate, systematic investor fraud that was more coherent than the truth, but that the jury had found entirely convincing. He was not innocent of negligence. He was not guilty of the crime as charged. His own attorneys had not been able to make that distinction clear enough. His ex-wife could. Dr. Vivian Cole had kept his name, not for him, because she had built her legal career under it, and because it was, by the time she had any reason to change it, simply the name under which she was known in the specific world of her work. She was 41 years old. She had grown up in Chicago, the daughter of a federal judge father who had spent 22 years on the bench and who had given her, through years of watching him work, an understanding of how courtrooms operated at a level that most lawyers spent careers trying to develop and that she had absorbed before she took her first law school class. She had a law degree from Yale and a doctorate in corporate law from the University of Chicago. She had spent 6 years as an assistant federal prosecutor before leaving to join the private practice that had, across the following 7 years, become one of the most respected corporate defense firms in the country. She had taken 17 cases that were widely considered unwinnable and had won 13 of them through the specific, exhaustive preparation of someone who did not accept the premise that a case was unwinnable until she had read every document in the discovery file herself. She had met Ethan at a legal industry event when she was 30. He had been drawn to her with the specific, focused intensity of a man who recognized someone operating at a frequency he found genuinely compelling. She had been careful. She had made him earn it. He had earned it. For a while, the marriage had been, in its early years, the specific productive thing that happens when two extremely intelligent people who genuinely like each other share a life. She had watched him build the company and found his mind in those years genuinely interesting. He had watched her work and understood, in those years, that her intelligence was not decorative. Then the company had grown beyond a certain scale, and the growing had required everything, and there had been nothing left. Not because Ethan stopped loving her, because he stopped showing up. Not dramatically, gradually. The way presence drains from a marriage when one person's world expands faster than the capacity of both people to remain centered in each other. She had said something. He had said he understood. She had said something again. He had said the timing was difficult. She had filed after the third conversation. The divorce had been clean because Vivian Cole did not do things that were not clean. The prenuptial agreement was clear. The financial division was fair. The attorneys on both sides described it as one of the most efficiently resolved high-net-worth dissolutions they had participated in. She had gone back to work. She had not looked back. She had not spoken to him in 4 years. Until she read the trial transcripts. She had not been following the trial. She did not follow things that were not her cases, as a general rule, and she had specifically not been following this one because it was his case, and because she had spent 4 years building a life that did not orbit around anything connected to Ethan Cole. Her partner at the firm, a woman named Dr. Sarah Okafor, who had been with her since the firm's founding and who was one of 3 people in the world permitted to say the difficult thing to Vivian without significant consequence, had placed the trial transcripts on her desk on a Tuesday morning. She had said, read the discovery file summary first, then the prosecution's financial expert testimony, then the defense's cross-examination. Vivian had said, I am not taking this case. Sarah had said, read it first. Vivian had looked at her partner. Sarah had said, I know, but read it. She had read it. It had taken her 4 hours. When she finished, she sat at her desk for 20 minutes. Then she went to Sarah's office. She said, the prosecution's financial expert is wrong about the revenue recognition timeline. Sarah said, I know. She said, specifically wrong. The emails they are using as evidence of intent were written in the context of a legitimate accounting discussion about a specific GAAP standard that changed in the relevant quarter. The prosecution has presented them as evidence of deliberate misrepresentation. They are not that. They are a CFO and a CEO discussing an accounting complexity that the prosecution's expert has either misunderstood or deliberately mischaracterized. Sarah said, "I know." She said, "Harrison did not catch it." Sarah said, "Harrison did not understand it well enough to catch it. It requires specific knowledge of the gap standard in question and the timing of its implementation." Vivian said, "Ethan's CFO was running operations that deserved scrutiny. But the specific charges, the investor fraud, the securities violations, those were built on a financial narrative that is wrong." Sarah said, "Yes." A silence. Vivian said, "I am not taking this case." Sarah said nothing. Vivian said, "He is being sentenced tomorrow." Sarah said, "I know." Vivian said, "If I walk into that courtroom tomorrow morning, I am going to need to file a motion for continuance and a motion to reopen the evidentiary record based on newly identified expert testimony contradicting the prosecution's financial analysis, and I am going to need to do it before the sentence is delivered." Sarah said, "Yes." Vivian sat in the chair across from her partner's desk. She said, "I do not want to do this." Sarah said, "I know that too." She said, "But you read it." Sarah said, "I read it." Vivian said, "And you are telling me to take it." Sarah said, "I am telling you that you already know what you are going to do. You have known since you finished reading the prosecution's expert testimony. I am just sitting here while you finish arriving at it." Vivian looked at her. Then she stood up. She said, "Pull the full discovery file. I need everything by 6 this morning." Sarah said, "It is already on your desk." She worked through the night. Not because she needed to. She was not someone who required excessive time to absorb a case file. She needed to understand this one completely before she walked into that courtroom, and completely meant completely. By 3 in the morning, she had identified 6 specific points at which the prosecution's financial narrative was either wrong or materially misleading. 3 of them were, in her professional assessment, correctable within existing case law through a motion for new trial based on prosecutorial misrepresentation of expert testimony. One of them was, in her assessment, significant enough to have altered the jury's verdict if presented correctly. She sat at her desk at 3 in the morning in the quiet of the office, and she thought about Ethan Cole sitting in a holding cell somewhere in this city, and she thought about the specific feeling of knowing that a person was about to spend the rest of their life in prison for something that the evidence did not actually support. And she thought about what it would say about her as a lawyer and as a person if she walked away from that, because the history was complicated. She had known at 6 in the morning when she read the prosecution's expert testimony. Sarah had been right. She had just needed to finish arriving at it. At 4:30, she drafted the motion. At 5:45, she called her assistant. At 7:15, she was in the car. The federal courthouse on that Tuesday morning in November had the specific charged atmosphere of a significant sentencing. Press in the gallery, investors who had lost money, Cole Technologies employees who had lost jobs, and the particular energy of a room that understood it was present for the end of something. Harrison sat at the defense table looking at his notes. Ethan sat beside him in the charcoal suit. He had not slept. He had not slept in 3 days in any meaningful sense. Not since the verdict. Not since the specific, irreversible arrival of 12 guilty findings that had removed from him, in a single afternoon, everything he had built for 20 years. He was not afraid. He was something more complete than afraid. The specific, hollowing state of a man who has understood that the story he has been telling about his own life has arrived at an ending he did not write. He had called his daughter the night before. His daughter was 19. She was at college in Boston. She had been composed on the phone in the specific way of someone who had been bracing for something for a long time and was now receiving the confirmation of what they had been bracing for. He had said, "I am sorry." She had said, "I know, Dad." She had not said, "I believe you." She had said, "I know, Dad." He understood the difference. He sat at the defense table and thought about his daughter and thought about 20 years of Cole Technologies and thought about the jury's verdict and thought about, for the first time in 4 years with the full undivided attention the thought deserved, his marriage. He thought about 3 conversations. He thought about walking into his apartment on a Thursday evening and finding a box of her belongings by the door because she had already packed what was hers and organized it for collection with the specific efficient thoroughness she brought to everything. He had not chased her. He had told himself he would give her space. He had told himself she needed to process. He had sat at his desk the following morning and worked, because that was what he knew how to do. He sat at the defense table and thought about that, and thought about what it said about him that his first instinct when she left was to go to his desk. He thought about it for the first time with the kind of honest attention that 20 years of unexamined success had not required him to give it. He sat with it. He had nothing else to do. The judge entered at 9:15. The room stood. The room sat. The proceedings began with the specific formal language of a sentencing hearing that has reached its final stage. The prosecution made its final statement. The investors who had lost money. The employees who had lost jobs. The specific, real damage of a company whose leadership had operated in ways that destroyed the confidence of the market and the savings of the people who had trusted it. The prosecutor was skilled. She framed Ethan as the architect of a deliberate, calculated scheme, and she framed it in language that was compelling and that was, in the most material respect, built on a financial analysis that was wrong. Harrison offered his statement in mitigation. It was adequate. It was not enough. The judge asked Ethan if he wished to address the court. Ethan stood. He said, "Your Honor, I want to be clear about something. I did not manage my company's financial operations with the oversight I should have. I failed my investors and my employees through negligence and through the specific arrogance of someone who believed his judgment was sufficient and did not verify what was being done in his company's name. I am responsible for that failure." He paused. He said, "I did not commit the crime as charged. I did not knowingly participate in a scheme to defraud investors. What happened at Cole Technologies was the result of my inadequate oversight of a CFO who was conducting operations I understood only in general terms. I understand that the jury found otherwise. I accept the verdict. I am asking only for proportionality in sentencing." He sat down. Harrison leaned over and said, "That was good." Ethan said nothing. The judge picked up his pen. He said, "Mr. Cole, the court has considered the sentencing guidelines and the severity of the conduct as established by the jury's verdict." The courtroom doors opened. The sound traveled across the full gallery. Every head turned. A black woman in a dark navy suit walked through the doors with the specific, unhurried purpose of someone who had decided what she was going to do and was doing it. She walked to the front of the courtroom. She placed her briefcase on the defense table. She said, "Your Honor, I apologize for the interruption. My name is Dr. Vivian Cole. I am entering an appearance as counsel for the defendant. I am filing simultaneously a motion for continuance of sentencing and a motion for new trial based on newly identified material errors in the prosecution's expert financial testimony. I have copies for the court, for the prosecution, and for current defense counsel." Her assistant, who had followed her in, distributed the documents. The courtroom was very still. The prosecutor said, "Your Honor, this is highly irregular." The judge said, "I can see that, Counselor. Dr. Cole, this court is aware of your reputation. I am going to need you to articulate the basis for your motion very specifically before I determine whether to grant the continuance." Vivian said, "Of course, Your Honor." She opened her portfolio. She said, "The prosecution's financial expert, in his testimony on the revenue recognition practices of Cole Technologies, characterized a series of internal email communications as evidence of deliberate misrepresentation to investors. I will demonstrate to the court's satisfaction that those communications were in fact generated in the context of a legitimate and documented internal accounting discussion about the implementation of ASC 606, the revised GAAP standard for revenue recognition that was being adopted by Cole Technologies in the relevant fiscal quarter. The prosecution's expert either did not understand or chose not to disclose that context. The jury's verdict on the most serious charges was materially dependent on their interpretation of those communications as demonstrating intent to defraud. The courtroom was silent. The prosecutor was looking at her notes. The judge was looking at the motion. He said, "Dr. Cole, I am going to grant a 48-hour continuance. I want full briefing on this matter from both parties, and I want your expert identified and available for the court's review by Thursday morning." He looked at the room. He said, "We are in recess. Midpoint question for you. Have you ever watched someone walk into a room and do something extraordinary for a person they had every reason to walk away from, and felt, watching it, something you could not entirely name?" The corridor outside the courtroom had the specific electric atmosphere of a place where something significant had just happened. Reporters, prosecutors moving quickly toward a conference room. Harrison collecting his papers with the specific expression of a man who had just been professionally superseded in the most public possible way. Ethan was led by a courthouse officer to a consultation room. Vivian followed. The door closed behind them. They had not been in the same room in 4 years. She set her portfolio on the table and opened it without looking at him. She said, "I need you to tell me everything you remember about the ASC 606 implementation discussion. Every meeting, every email, every conversation with the CFO about the revenue recognition timeline. I have the discovery documents, but I need your recollection." He said, "Vivian." She looked up. She said, "Ethan, I need you to focus. You have 48 hours and I need everything you can give me." He said, "Why did you come?" She said, "Because the evidence is wrong. Because your attorney missed something that should not have been missed, and because a man being prosecuted on the basis of a material misrepresentation of financial evidence is something I am not able to walk away from." He said, "I am not just any man." She said, "No, you are the most complicated man I have ever agreed to represent, which is exactly why I need you to answer my questions and leave the other conversation for after." He said, "Is there going to be an after?" She looked at him. She said, "There is going to be a Thursday morning. Let us get to that first." She worked for 46 of the 48 hours. Not continuously. She slept 3 hours and ate twice, and did both with the efficient practicality of someone who understood that a mind that was not rested was not operating at the level this required. She brought in Dr. Marcus Webb, one of the country's leading forensic accounting experts, who reviewed the prosecution's expert testimony and the underlying documents and produced a 14-page analysis that identified, with specific technical precision, the points at which the prosecution's characterization of the revenue recognition emails was either mistaken or incomplete. She coordinated with Harrison, not warmly, but professionally, to ensure that the existing trial record was fully integrated with her new filings. She prepared her argument for Thursday morning with the specific, exhaustive thoroughness of someone who understood that this motion had one chance. On Wednesday evening, she sat in the consultation room with Ethan for 2 hours. She asked him everything she needed to ask. He answered with the complete honesty of a man who had nothing left to manage. At the end of the 2 hours, she closed her portfolio. She said, "I think we can get you a new trial." He said, "You think?" She said, "I do not promise outcomes. I promise preparation. The argument is correct. The evidence supports it. The outcome depends on a federal judge who I believe to be intellectually honest. That is the best I can give you." He said, "It is more than I had yesterday." She said, "Yes." She picked up her portfolio. He said, "Vivian." She paused. He said, "I know this is not the moment, but I need you to know something." She waited. He said, "I have been sitting in a holding cell for 3 days thinking about the conversations we had. The 3 times you told me what was happening to the marriage. I understood them at the time as problems to be managed. I did not understand them as the truth of what you were experiencing." She said nothing. He said, "I am not telling you this because I need something from you right now. You are my attorney. I understand that. I am telling you because I have had 3 days with nothing to do except be honest with myself, and this is the most important honest thing I have arrived at." She said, "I hear you." She did not say anything else. She went back to her hotel and worked for 4 more hours. The courtroom on Thursday morning had a different quality from Tuesday. The gallery was the same: press, investors, former employees. But the energy was different. Not the finality of Tuesday. Something more uncertain. The judge entered. Vivian stood. She made her argument for 52 minutes. Not a minute less. Not a minute more. She walked the court through the ASC 606 standard, its implementation timeline, the specific quarter in which Cole Technologies had been adopting it, the internal communications that the prosecution had characterized as evidence of fraud, and the precise technical reasons why those characterizations were either incorrect or incomplete. She introduced Dr. Webb's analysis. She addressed the prosecution's anticipated counterarguments before the prosecution made them. She cited 7 specific precedents in federal court where the mischaracterization of accounting communications had been found to constitute material error sufficient to warrant a new trial. She spoke with the composed, measured authority of someone who had prepared so completely that there was no question she could not answer and no argument she had not anticipated. The prosecutor cross-examined Dr. Webb for 38 minutes. Dr. Webb answered every question with the specific, patient precision of someone who had also prepared completely. The judge asked both parties to submit final written briefs by 5 o'clock. The ruling came at 9 the following morning. The judge found that the prosecution's expert testimony contained material misrepresentations regarding the accounting context of the defendant's internal communications. He granted the motion for new trial on the securities fraud and wire fraud charges, the charges that carried the life sentence, and dismissed the conspiracy charge on the basis of insufficient evidence once the financial expert testimony was removed from the evidentiary record. The lesser charges, inadequate oversight, failure to supervise, remained. Ethan Cole was not going to prison for life. He was going to face a new trial on the securities charges, which Vivian's analysis had materially weakened. He was, for the first time in 14 months, not looking at the rest of his life in a federal prison. The courtroom reacted with the specific, complex energy of a room full of people who each had a different version of what justice looked like, and who had just watched the picture become considerably less certain. Ethan sat at the defense table. He did not look triumphant. He looked like a man who understood that he had been given back something he had not known how to value the first time, and who was not going to make a production of that understanding in a room full of people who had legitimate reasons to be conflicted about his situation. He looked at Vivian. She was already packing her portfolio. She was professional. She was efficient. She was the same person who had walked through those doors 48 hours ago. She was not his wife. She was his attorney. That distinction remained. But something had shifted in the 48 hours, and both of them knew it. They sat in the consultation room one more time after the ruling. She needed to walk him through the next steps, the new trial timeline, what to expect from the prosecution, what the remaining charges meant, and how the new evidentiary record changed the landscape. She did it efficiently and completely. When she finished, he said, "What do I owe you?" She said, "My standard rate. My office will send the billing." He said, "Vivian." She looked at him. He said, "I know what you did. I know what it cost you, professionally, personally, to walk into that courtroom for me. I am not going to pretend I do not understand that." She said, "I walked in because the evidence was wrong." He said, "I know that is why you walked in. And I also know that it was a decision that required you to do something for me that the history between us did not require you to do." She said, "No, it did not." He said, "I know." She picked up her portfolio. He said, "I want to ask you something. And I want you to understand that I am asking it with no expectation. I am asking because I think I owe you the honesty of asking directly rather than managing around it." She waited. He said, "Is there any version of what comes next, of whatever my life looks like from here, where you would consider having a conversation with me? Not about the case. About the things I said in the consultation room on Wednesday evening." She looked at him for a long time. She said, "You have a new trial ahead of you. You have lesser charges that need addressing. You have a company that is in receivership and a reputation that has been damaged in ways that are going to take years to repair." She paused. "You have a daughter who said, 'I know, Dad,' on the phone the night before you were going to be sentenced, and I think you understood what that meant." He said, "Yes, I understood." She said, "That is where I would start. Not with me. With her." He said, "You are right." She said, "I usually am." She picked up her briefcase. She said, "I will be in touch about the new trial timeline." She walked out of the consultation room. She walked down the corridor of the federal courthouse with the specific, composed stride of someone who has done what they came to do and is now returning to the rest of their life. In the elevator, she took a breath. Just one. Then the doors opened, and she walked out into the November morning. Ethan Cole had built a company worth $90 billion. He had also built a marriage he had allowed to collapse through the specific, unchecked momentum of a man who believed that his presence could be substituted with his results, and who had discovered, through 14 months of legal proceedings and 3 days in a holding cell, that it could not. Vivian Cole had spent 4 years building a career that did not orbit around him. She had become the best defense attorney in her field. She had won 13 of 17 cases considered unwinnable. And on a Tuesday morning in November, she had read a prosecution's financial expert testimony and found it wrong. and she had spent the night drafting a motion, and she had walked through the doors of a federal courthouse and placed her briefcase on the defense table of the man she used to be married to, and said, "Your Honor, I apologize for the interruption. Not because he deserved it, because the evidence was wrong. Because a man being prosecuted on the basis of a material misrepresentation was something she was not capable of walking away from. That was who she was. That had always been who she was." And Ethan Cole, sitting in a consultation room on a Thursday morning with a new trial ahead of him and a life he had to rebuild from the inside out, had finally, too late for the marriage, but perhaps not too late for the man, understood what he had chosen not to show up for. She had told him where to start. Not with her, with his daughter. He made the call. His daughter answered on the first ring. He said, "I want to start over. Not with everything. Just with you and me. Can we do that?" She was quiet for a moment. Then she said, "Yes, Dad. We can do that." That was enough. For now, that was enough. Final question for you. Have you ever done something genuinely difficult for someone who did not deserve it, and discovered, in the doing of it, something important about who you actually are? Leave your answer below. Your voice belongs in this conversation. If this story found something real in you today, share it with someone who needs to hear it. One share. It costs nothing and means everything. I love you all. I will see you in the next story.